Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hi, everybody, and welcome to this special California edition of 3Bs on the Law. In 2020, Governor Newsom signed only 372 new laws into place, the fewest since 1967. My partner, Lindy Bradley, is here today to help us talk about all of the new laws. And just to make things easier and to make things a little shorter, we've broken them up into two segments. This first segment is going to do with employment law, and the second section is going to do with other laws that may be of interest to people and to businesses in particular. So Lindy is here. Thank you so much for being on. Lindy is one of my partners. She is a partner of Bradley and Gamelik, and she practices in supermarket and restaurant defense work. She also sits on the board of the Association of Southern California Defense Counsel. Lindy, welcome. Thank you so much for being on with us today.
Thanks for having me again.
Thank you, most importantly, for not making everyone just listen to me drone on about all the new laws.
No problem.
And just a reminder before we get started, not a new law. Companies with 5 or more employees had to complete their sexual harassment training by December 31st. So if you haven't got that completed, you need to get it done as soon as possible. Because while you're currently not in compliance, if you haven't done it, better late than never. And remember, employees need 1 hour and supervisors are required to have 2 hours of sexual harassment training. And Lindy, I think you were going to start us off with the new laws by talking about AB 685.
Yes, so let's get into AB 685. This is a new law related to COVID exposure. And this law says that you have to notify your employees within 24 hours of a known exposure that an employee has been exposed to someone with COVID. The law also expands Cal OSHA's authority to shut down a work site if they feel that the work site or business is what is considered an immediate hazard. So if you've listened to other episodes of 3Bs on the Law, you know that 3Bs has advocated having a response team in your business. Our law firm has a wonderful response team. They are responsible for keeping our business open from the beginning of COVID to the present, and really assists when you need to have a fast response to an ever-changing situation like we have with COVID.
Yeah, one of the things I'm most proud of our firm is how we have responded to the pandemic. I think our response team has done a fantastic job.
I agree 100%. They've made it possible for us to continue going to work, so I'm grateful.
Yeah.
So I also am going to talk about workers' compensation law. SB 1159 is another COVID-related law that is intended to assist essential workers by presuming that those essential workers have, if they do come down with COVID, that they caught COVID in the course and scope of their work as an essential worker. The caveat to that is that an employer is still able to contest whether that person has actually gotten COVID in the course of their work.
Yeah. And that law sunsets, I think, in the end of 2022, if I recall correctly.
So there's 2 years on it. Maybe it's a hopeful law, which was created with the idea that we won't need this law after 2022, which would be wonderful.
Let's all hope that is, in fact, the case.
Yeah.
So the next law we want to talk about is AB 2257, which follows up on last year's hotly debated AB 5. And AB 5, if you recall, was the law that classified most independent contractors as now being employees. So what AB 2257 did is it created and expanded the list of exemptions and now allows musicians, writers, business consultants, and several other professions from being exempted as classified as employees. And so If you want to know whether or not your profession is exempted, you need to look at AB 5 and AB 2257 to determine whether or not your job classification or profession is in fact exempt. And if you were paying attention at all to the election, other than the hotly reported presidential election here in California, Proposition 22 was passed by voters, which allowed independent contractors to maintain their status from app-based companies such as Uber and Lyft. But while they are still classified as independent contractors, they are now eligible for limited health care and other benefits such as a guaranteed wage for time that they spend behind the wheel.
I think a little bit of 3B trivia is that lawyers are considered independent contractors under the law. We continue to be because we were considered independent contractors at the onset. Is that right?
Yep, we can be classified and hire independent contractors.
Okay, and so another popular law, which has come into play in 2021, is the minimum wage in California. So as of January 1st, 2021, the minimum wage in California is $14 for businesses with more than 25 employees. For businesses that are less than 25 employees, the minimum wage is $13. However, on July 1st, the minimum wage in Los Angeles will go up universally to $15. How'd I do?
I think you did a great job. I think it's 14 and a quarter for businesses under 25 and 15 currently, and everything goes up to 15 as of July 1st across the board. And so, you just need to make sure that you comply and make sure you're paying your employees wherever you happen to be in California the proper minimum wage, because different counties and cities have different minimum wages. So we can't stress that.
Yes, check the county because it may be different. Los Angeles County is its own universe.
Yep.
So.
Perhaps the biggest law affecting employers that came into effect on January 1st of 2021 is SB 1383, which expands the California Family Rights Act. This law requires businesses now with 5 or more employees to provide up to 12 weeks of annual unpaid job protected leave for family and medical needs. To be eligible, though, an employee does have to have worked 1,250 hours during the previous 12-month period and have been with the company for at least 12 months. This law lowers the threshold for the number of employees that a business has to have before it is required to provide this protected leave. With the COVID pandemic raging on, I think a lot of small businesses are going to struggle to provide this job protective leave. If they have 1 or 2 employees out with COVID that require this leave and they have to hire a temporary employee or try to fill in the gaps, I think a lot of companies are going to have a really difficult time with this, and you really need to plan ahead for this contingency. And you also need to get a policy in place so that your employees understand their rights as well, so you don't unwittingly not give someone leave that they're entitled to and find yourself in the midst of a lawsuit down the road.
I agree with you. This particular law is potentially going to be very painful for small businesses with a small number of employees.
Yeah.
If you get multiple employees that are infected with COVID in this particular time period, that could be very damaging to a small business. So
Yep.
plan ahead.
And then AB 2017 allows employees to use sick days to attend to sick family members and use them however they deem fit. Employers cannot deny an employee's use of their sick leave for whatever reason the employee deems necessary. There's a little caveat at the end of the law. And so I think it's going to be interesting to see what kind of sick excuses are used for this law coming up. I think we're going to see even more creative uses. So maybe at the end of the year, we'll ask people to submit what crazy sick excuses they've got, because those are always fun to look at.
Top 10 list for sure to see who has the most creative request. So another issue having to do with leave is SB 1123, which has expanded the paid family leave program to allow an employee to take paid family leave for situations arising out of a family member who is in active duty in the military. And I think this is a really good law that's come into effect, supportive of our active service folks.
Yeah, I agree. And everybody knows California takes equal pay and the gender pay gap very seriously. SB 973 requires larger employers, so employers with 100 or more workers, to annually submit data to state officials based upon race, ethnicity, and gender, so that they can study how we are doing with respect to those pay gaps.
Okay.
And my favorite one, just because I want to hear you say the name of the case, Lindy.
I'm going to talk about Furlecken versus Apple, which is my best guess at how we pronounce that case name. It's a very interesting case, which was originally argued in 2017, was recently affirmed by the Ninth Circuit. It has to do with wait time spent by employees of Apple who were having mandatory bag checks when they left their business. So the employees were required to check out and then wait a certain amount of time while their bags were being checked to make sure they weren't taking devices in their bags when they left. The only problem with it was that Apple wasn't paying them. So this case affirmed that it's okay for you to require your employees to stay and have a security check of your bags as long as you're paying them. So
right. And in this case, some of those bag checks we're taking, if the store was busy, could take 10, 15, 20 minutes, and literally as long as the break that the employees were given. So you need to really be mindful that you're not, if you're going to do that you're either doing it quickly, meaning in a matter of, very short time period, or if it's taking longer, that you pay your employees. And then the last case that I wanted to just mention is Midwest Motor Supply versus Superior Court. And essentially that just reaffirms forum selection clause in an employment agreement. And so under Labor Code Section 925 in California, an employer cannot require an employee who primarily resides in California as a condition of employment to adjudicate a claim outside of California on a claim that arose in California, and it can't deprive that employee of the substantive protection of California law. So for example, if you're an Ohio company and you hire a California employee, you are subjecting your company to the laws for that employee of the state of California. And I think a lot of companies don't realize that, and they try to, for example, I'm picking on Ohio, but it could really be any state, to comply with Ohio law, where in reality, California law would apply.
It's almost like reverse forum selection.
Right.
So that's very interesting.
And so with that, thank you for joining us for this special California episode of 3Bs on the Law to discuss the new employment law. Please make sure you check out part 2 of this program, which will deal with the other laws that may be important to businesses and just people in general. Thank you, Lindy, so much for joining us. I really appreciate it.
My pleasure.
Have a great evening, everybody. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.